I want to tell you about the judge who refused to help us negotiate this case, forcing us to try this case. You want to know what this is about? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now this is a medical malpractice case. My client felt that her doctor was careless, and that carelessness was a cause of her injuries. And now she sued her doctor for medical malpractice. And now the defense attorney I knew very well. I'd worked with him many times before on other cases. I respected him. He came from a very good defense firm in New York City, and he was a straight shooter. From the very beginning of this case, the defense lawyer had told me, listen, the doctor feels he did absolutely nothing wrong. The insurance company representing the doctor also believes that he did nothing wrong. There is no way we're ever going to settle this case. We're never going to negotiate. So that told me we're going all the way to trial. That meant 2 or 3 years down the road, we would be at trial, and now a jury would ultimately decide whether my client was slightly more likely right than wrong than what she was claiming was true. When I first had the medical records reviewed, my medical expert came back and told me, yes, we have good liability. Yes, we have good causation. Yes, we have good damages. Those are the 3 things that we need in order to make out what we call a prima facie case. Now, what does that mean? It simply means that we have the 3 elements necessary in order to put our case in front of a jury. Now, let's break it down a little bit further. It first means that my expert confirmed that we had a valid case because he believed that the doctor who treated my client violated the basic standards of medical care. And he also believed that those violations were a cause of this patient's injuries. And he also believed that my client's injuries were significant. And all because he confirmed each one of those 3 elements, that now allowed me to proceed forward with a lawsuit on my client's behalf. Otherwise, we couldn't even get in the door. We would not be permitted to even start a lawsuit without having a medical expert confirm all 3 of those things. Even though my medical expert confirmed we had those things, I actually had to confront him and say, wait a second, liability doesn't seem clear-cut. He said, you know what? You're absolutely right. Liability is okay. I said, okay? How can I go to trial 2 years down the road if liability is just okay? Okay doesn't cut it. Either it's clear cut or it's not. If it's in a gray area, now I've got a problem. Now I'm rolling the dice hoping that the jury's going to rule in our favor. That's not good. I said, wait a second. Even if the jury does find that the doctor was careless, now, really that carelessness caused this injury? And he said, well, you know what? We call that proximate cause or causation. There has to be a link between the improper care and the injuries that you suffered. If there's no connection, there's no bridge, guess what? Then there's no case. And I said to my expert, wait a second, causation doesn't appear to be that strong. And he said, you know, as you bring that point up, you might be right. I said, I might be right. So now you've told me what originally was good liability, good causation, good damages. Now I've just confronted you, and we're not even at cross-examination yet. We're at the beginning of the case. Now you begin to hedge and say, hey, wait a second. Okay, liability's not that great. It's okay. And causation, is there a link between the doctor's carelessness and your client's injuries? Yeah, but maybe it's there, maybe it's not there. I said, what? What are you telling me? Either it is there or it isn't there. There's no in between. And he says, for our purposes, yes, it's there. Okay, so you know what that told me? That told me we didn't have such a great case. Well, what about her injuries? Her injuries were in fact significant, but they were not over-the-top significant. They were not totally and permanently disabling, so now her life was over. She would be able to get on with her life, although she would have to limit some of her activities. All right, so the damages would be limited, but going back to my expert's opinion about liability and causation, I knew we didn't have the strongest case possible. And you know, during the course of litigation, I had an opportunity to speak to the defense attorney a number of times. I would see him in court on these status conferences to update the court on what was going on. I had an opportunity to speak to him and chat with him briefly during these question and answer sessions known as a deposition, which is testimony that's given under oath in the attorney's office. And when he had a chance to question my client, and later on when I had a chance to question his client, the doctor. And during that time, I got the sense that his hands were tied. I got the sense that he really would have liked to try and settle this case, or at least begin negotiating. But you know what? His client, the doctor, refused to negotiate, as well as his insurance company. So he'd come to me and say, you know, if it were up to me, I would try and settle this case. But my client says absolutely not. And so does the insurance carrier. So now we proceed forward. And now we get all the way to trial. And now the trial assignment judge turns around, we're ready for trial, and says, okay, counselors, are you ready to pick a jury? And we both say, yes, we are, Judge. Now, go pick a jury. So now we go ahead and pick a jury, myself and my opponent. And you should know something. Picking a jury doesn't mean selecting those jurors whom we actually want to sit as jurors on our case. Instead, it's totally different. We actually remove those people whom we don't want to sit on our jury. And whomever we are left with, that represents our jury. It should really be called jury deselection rather than jury selection. So anyway, this goes on for a number of hours, and by the early afternoon, we have now selected 6 members of the community who have told us that they can be fair and impartial in deciding your case. In addition, we have been told to select 3 alternate jurors. Why? In case any one of the first 6 people are no longer able to continue with their jury service, the judge will then go ahead and select randomly one of those alternate jurors to then fill in for one of those people who can no longer continue. So now we've picked a jury. We report back to the jury clerk that we are ready for trial. We now have a jury. The jury clerk tells us that we've been assigned to a particular trial judge. Go up and see him now before he leaves for the day. And now my opponent and I go up to the judge's private chambers on a floor with security. And now we get to see the judge. We walk in. We introduce ourselves. I've never been in front of this judge before, and neither has my opponent. I have, however, heard about this judge, and I'm sure my opponent has as well. And the first thing that I did hear about this particular judge was that he will never try and negotiate with the attorneys before trial. And I thought, that's pretty interesting. Maybe he's not going to do that in this scenario. Maybe he'll try and negotiate to get the 2 parties to come together so that we don't have to try this case. That would be interesting. So I was anticipating, but I didn't know what actually would happen. So now, what happens during this conference? What happens is the judge knows nothing about this case. He's just been randomly assigned by the trial assignment judge to try this case. Now, he wants to know, okay, counselors, what's this case about? Now, you'd think that the attorney would go ahead and talk for 30 minutes giving all these great details about why we believe we're entitled to a verdict in our favor and why we have such great damages, right? 30 minutes, that's a heck of a long time. No, no, no. The judge doesn't want to hear 30-minute discussion. He wants a 1-minute summary of what's this case about. Judge, this is a failure to diagnose lung cancer case resulting in the patient's death. She was a 40-year-old woman with 3 young kids. Now the judge has some idea of what this case involves. Okay, now he turns to the defense. Counselor, what's your position? Meaning, do you have money on this case? Are you willing to negotiate? Are you willing to try and settle this case? Yes or no? Do you think you have a defense? So now the defense attorney says to the judge, Your Honor, we believe this is totally defensible. However, even though we think it's totally defensible, we might be receptive to the possibility of negotiating. Now, this is the first time I hear this. This is the very first time. And I had an inkling that something like this might occur. Why? Because the defense lawyer had taken a really, really long time to notify me about which experts they were planning on bringing into court to testify in their behalf. Now, you should know, in a medical malpractice case here in New York, we are obligated to notify our opponent that we're bringing in various medical experts. We have to identify not the name of the person we're bringing in, but the type of specialty doctor that we are bringing in. We have to give our opponent the doctor's credentials, where they went to school, where they did their internship, where they did their residency training, if they have a fellowship, where they licensed to practice medicine. All of that information has to be turned over and provided to the defense. Why is that? I'll tell you why. So that now they can take that information, plug it into a computer program, and now it spits out the doctor's name. Then they go ahead and try and dig up as much dirt as possible on this doctor so they can use it for cross-examination purposes. Okay? That's what happens for both sides. But I knew, because my opponent took a really long time and only notified me a few days before trial, and they're supposed to do it much earlier than that, but because he delayed such a significant amount of time, I had the sense that there was a problem. Now, I didn't know exactly what the problem was, whether he couldn't find an expert to come in and testify, or whether this was a delaying tactic, or whether this was simply a strategy to throw us off track, thinking or trying to believe that he had a problem with a medical expert when in fact he may not have. So there are a number of different reasons or strategies that are used when notifying our opponent about which medical experts we are bringing in. So this is amazing. For the very first time, I now begin to hear that, hey, they may be willing to negotiate. That's great. But now the judge says, terrific, let me see the pleadings, counselors. Now, pleadings, what are those? Those are the actual legal documents making the allegations against the people whom we have sued. So I have to provide the judge with those allegations, those pleadings. And likewise, the judge wants to see what the answers to those allegations were. Now, the judge wants to know, are there any defenses, what we call affirmative defenses? The doctor turns around and says, hey, judge, why did they sue me? The patient caused all of her own problems. She's responsible, not me. That's an affirmative defense, known as a culpable conduct defense. Or they may turn around and say, hey, judge, why did they bring this lawsuit now? This is untimely. We ask that you throw this case out. Or another affirmative defense is, hey, judge, the plaintiff, the injured patient, and her attorney don't have the necessary elements in order to bring this type of case. We ask you to throw that case out. So the judge wants to see all that before we ever start trial. And in addition, the judge wants to see a trial brief to know what legal issues are going to come up or are anticipated to come up during the course of trial. And your attorney better have a trial brief ready to go, which shows the judge not only are you prepared and ready, but it anticipates certain legal issues that will arise. And now we've given the judge certain law explaining why he should rule in our favor when this issue does come up. Okay, so now this conference has taken all of 2 minutes. The judge now has the pleadings. He looks at it quickly and says, terrific, we're starting tomorrow morning at 9:30 a.m. Be there promptly. You're now dismissed. And now we both start to get up and say, Your Honor, don't you want to try and see if you can negotiate this? There might be an opportunity to settle this case. And he turns to us and says, counselors, sit down. Okay, so we sit down. And then he starts to lecture us. He says, listen, you were sent up here by the trial assignment judge. I am not the trial negotiating judge. I am not the pretrial negotiating judge. I am the trial judge. I am here to try this case. Either you try the case or you don't try the case. You don't come up here asking to settle this case. You guys are adults. You know how to do this. This isn't your first trial. This isn't your first case. Each of you know that if you want to try and negotiate or settle this case, you two get together. You have each other's phone numbers. You know where the offices are located. Pick up the phone. Call each other. Decide. Do you want to negotiate? Do you want to try and settle this case? If you do, settle it outside the courtroom. I am not participating in any negotiations. You are dismissed. As my opponent and I are going back downstairs to the jury room to get our things, we looked at each other and said, have you ever encountered a judge who refused to try and negotiate a case? Instead, all he wants to do is try cases? He said, no, never. So I said to him, are you interested in trying to negotiate this case? And you know what he said to me? He said, listen, my hands are tied. If it were up to me, I would try and settle this case, but I can't do it. The doctor refuses, the insurance carrier refuses, and that's the end of it. So what did that mean? It meant the next morning we were back in court trying our case. An entire week of trial goes by. We put on all of our witnesses, the defense puts on all of their witnesses, and now the jury comes back with their verdict. Finally, after 2 long years, the jury finally decides, yes, that we were able to show that we were more likely right than wrong, that the doctor was careless. Okay, we got past number 1. Number 2, was the doctor's carelessness a cause of this patient's injuries? The answer was yes. Now, the key question, how much money do you give this patient and her family as a result of what was done improperly? And you know what they did? They gave her a very small amount of money, much smaller than we had asked for. Now, I had made a significant demand at the beginning of this case. I had made a demand throughout the entire litigation. The demand was $1 million. But you know something? I knew that that was an unrealistic demand. The defense lawyer knew that that was an unrealistic demand. But if the defense had gone ahead and tried to negotiate, then we could have gotten down to real numbers about what we really felt this case was worth. And honestly, this case had a true value of between $350,000 to $500,000. That's the ideal, assuming we had great liability, assuming we had great causation. But the fact was we didn't. We didn't have those great things. So that meant that the value of this case was significantly lower. So now, after the jury has reached their verdict, my adversary and I meet up in the hallway as we're getting ready to leave. And he comes over to me and he says, I want you to know something. I had made a recommendation to the insurance carrier that this case had a value of almost exactly what the jury came back with at the very beginning of this case. That was my impression, my opinion, that I had told the insurance company about. But they never allowed me the opportunity to try and negotiate. Had they given me that opportunity or that authorization, then guess what? We might have been able to avoid all this 2 years worth of litigation. I said, well, we can't do anything about it now. My client either has to live with it or try and appeal the decision. So let's get back to the headline that I raised at the beginning of this video. Here was a judge who refused to negotiate. And I'm telling you something, if the judge had made an effort, I'm pretty sure that the defense lawyer would have gone back to his insurance company and said, hey, listen, the judge put pressure on us and he believes that we're going to get hit for a verdict over and above what I valued this case at. Give me some money so I can go ahead and start negotiating and hopefully reduce the risk that we're going to get hit for a large verdict. Will you do that? And if the judge had taken the time to do that, then maybe, just maybe, we could have avoided the entire trial. But in this instance, he didn't want to negotiate. He was the trial judge, and all he wanted to do was have us try our case. So why do I share this interesting story with you? I share it with you just to give you an inside look at what happened in one particular case where one trial judge refused to negotiate or help the attorneys negotiate and bring them together to reach a mutually agreeable settlement. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, well, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.